Hey, Dwayne, I'll get started momentarily, brother. Just trying to get something going here. Dope, dope. Me as well. All right, well, we're doing it. All right, here we go. What's happening? What's happening? We are making this happen. AB5, what's good, Sean? Shout out to Dwayne, shout out to Mickey, small group, good group of people. Hopefully people will come and let me turn this off. Hopefully more people will come through. And let's get this going. I'm gonna share my keynote. Bam. Okay. Everybody sees this okay? Yes, great. Great, great, great. Now this is focused on DJs, of course, but I think the principles really apply to all of us who are, a lot of us in entertainment, but I know, Dwayne, it definitely hits you. And just all of us that just have been doing gig to gig life for such a long time. So my disclaimer, as you all know, I'm not a lawyer. I like doing research. I'm not a lawyer. I share my research because sharing is caring. I'm not a lawyer. This is educational. I want to share with you the research I have found out and have a discussion about it and see, if anything, the main thing I want you all to walk away with is that you are in knowledge of like what's going to impact you and specifically the details that hit us the hardest in the sense, or the hardest thing to navigate. And there's only a few of us in here, but what do you do? Let me know, tell me in the chat. I'm being engaging, people. But I DJ and do music, and I'm starting a coaching program for DJs. I know some friends of mine are actors. They do music, they sing. Some friends of mine are bartenders, like Dwayne. I have other friends who coach. I know people who are hairstylists, people who are agents, run their own DJ agencies. Sean is a dope music producer, also A&R and product developer for a producer. So we're kind of across the board, but the thing that we have in common is that we are independent contractors. Moving into AB5. So let's just do a quick overview of what it is. AB5 is an assembly bill authored by Assemblywoman Lorena Gonzalez. It's aimed to protect Uber and Lyft drivers. I watched an interview of her earlier in the summer where she was interviewed earlier in the summer talking about basically the genesis of all this. And what she was saying is that she's had plenty of conversations with drivers rideshare drivers who have had lots of issues based on how the model of Uber works. They're getting basically pennies on the dollar for all the work that they're doing. And while the C-suite folks, CEOs, CMOs, et cetera, are making like tons of money, these people are not making a lot. And if they get into an accident, actually this had happened. She said, I talked to a driver who got into an accident, not of his own fault, ended up not being able to work anymore because there's restrictive laws with Uber and Lyft and accidents. So he lost his work. He lost his car because his car got totaled or severely messed up. He had injuries, so he had hospital bills to rack up and no way to work to make up for those or to pay for these bills. All through an accident that wasn't his fault. So this is what she explained was the origin of what AB5 was about. And she said, it's really unfair that these drivers are not making a lot and facing these kind of issues when the C-suite folks are making millions upon millions, if not billions of dollars. So what AB5 now does, now that it's passed, it codifies the Dynamex rule into law. So give a little bit of history. What is Dynamex? The Dynamex case is an important case because what it was about was misclassification of employees. So what happened is Dynamex is a national on-demand delivery service with several large business clients like Office Depot and Home Depot. Prior to 2004, all delivery drivers were considered employees. However, in 2004, Dynamex abruptly reclassified the drivers as independent contractors strictly to save money. The drivers lost their ability to set rates. They were required to use their own vehicles and pay for all transportation expenses, pay for uniforms, Dynamex uniforms with their own money. The work was also assigned solely at the discretion of Dynamex dispatchers. So what happens is these drivers are working for this company, all's good. All of a sudden the company's like, you're on your own, but you have to wear our shirts. We're gonna slap our logos on your trucks. You're gonna work when we say you work. And you're responsible for all the fees, all right? But you still work for us, but here are the conditions. So in 2005, a worker sued. In 2011, the court certified the case as a class action suit. And in 2018, the court ruled that drivers were then misclassified. So that led to a cascading effect for independent contractors. It also brought the ABC test into effect, which has been law since 1979, but it codifies this case, or it codifies the test into law. Why this matters? Because now it really makes a hard line on who's the independent contractor and what the criteria is for it. And what this means is a major shift in how employees or potential clients that we want to work with now engage with us. It really is just, do they work with us as employees, or do we work with them on an independent contractor, business to business basis? So what is Burello? Burello is a test that was also addressed in the Dynamex case that has a different set of points if the ABC test doesn't apply. If there are any questions you have, hit me in the chat and I'll stop to clarify. So we have the Dynamex case, which introduces this ABC three-prong test. Burello then applies because there are exceptions to the ABC rule, and there are these 9 points about Burello, which is the right to control test. So if you are able to discharge at will without cause, if you are the one performing the service, engaged in a distinct occupation or business, or work in an occupation where the locality of the work is done under the direction of the principal or by specialist. Just going through this list, this is basically saying you're an employee and not an independent contractor. Are you still with me? Just drop me a yes in the chat. This is a lot of information. Okay, great. So let's break down AB5. Like I was saying, it codifies, great. It codifies dynamics to a three-pronged ABC test. This test has been around since 1979. It's not brand new, but now they're saying this is super legit. We have to follow this. What this also means, if, let's say, you run a restaurant, or let's just say, Dwayne, you are a bartender, you work for a restaurant. The restaurant has to prove that you're an independent contractor. You have to assume that you're an employee, and the restaurant has to prove that you're an independent contractor based on this test. So it's not on you to prove it, it's on your employer. So if you're hiring people, it's on you to show that they're independent contractors and they fit the criteria. This law also has expansions to include unemployment insurance and other labor law protections, given the fact that this is making changes to the existing labor law contract. So this thing runs deep, but this is really what the main focus is. And if it doesn't hit the three-prong test, then we move into the Burello test. And there's exemptions there, we'll get into that. So here we are, the ABC test. It seems simple. If the person you are hiring is free from the control and direction of the hiring entity in connection with the performance of the work, both under contract for the performance of the work and in fact. Meaning, I am hiring an accountant. I'm a DJ. The accountant is free from my control. They do what they do. They perform their work how they perform their work. I don't control that. And in actuality, I don't control their work at all. So that's what this clause means. B, the person that performs the work, the person performs work that is outside the usual course of the hiring entity's business. In its simplest form, the accountant does accounting work, I do music. They don't do what I do, right? With C, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. The accountant does accounting work. That's what they do. That's what they're doing for me. That's it. If they pass these tests, you're technically okay. If you pass 2, you're not okay. They're considered an employer. If you pass 1, employer. You have to pass all 3. But there are issues. Prong B is deceptively simple. So there is a breakdown from the Senate Committee on Labor, Public Employment, and Retirement, and they give these examples. A retail store hires an outside plumber to repair a leak or an outside electrician to install an electrical line. The services of the plumber and electrician are not part of the store's usual course of business, and the store would not reasonably be seen to have them as an employee. Very easy distinguishing factors, right? They do plumbing, they do electric work, I sell product. I can't say that they do what I do, so I can't hire them as an employee. Part B, a clothing manufacturing company hires work-at-home seamstresses to make dresses from clothing and patterns supplied by the company that will thereafter be sold by the company. Or when a bakery hires cake decorators to work on a regular basis, the workers are part of the hiring entity's usual business operations. Gets a little more detailed here. So the seamstress sews. All I'm doing is selling dresses. But what the seamstress does fuels what I'm able to do. I could not do what I do without the seamstress. I could not sell dresses without that. Therefore, they look at that as an employer. I cannot sell cakes if I have cake decorators working on cakes every day of the week. They're considered an employer. So in the second example, the worker's role within the hiring entity's usual business operations is more like an employee than that of an independent contractor. It gets really tricky here, part B. And with all the videos that I've watched on other lawyers talking about this, B is the stickiest point of all three prongs. So AB5 is designed to help those workers in point 2. Here's where I think their intent is great. The wage order, meaning like pay, insurance, all that stuff, could be avoided if that could be avoided for workers who provide services comparable to employees, but are willing to forego the wage order protections. Other workers who provide similar services and are intended to be protected would suffer and be displaced. So basically, they're a seamstress that would be considered an employee, but this seamstress says, well, it's cool, you can just pay me $10 and don't worry about insurance. Then this person who has a job and is doing great will then lose their protections. They're trying to avoid this race to the bottom. So with the Dynamex decision, the court is saying that there is a thing known as a traditional genuine independent contractor. The court focused on the centrality of the task to the business model. This is the most important point. Under Burello, which is the 9-point test, the examples of the seamstress and the bakery would be prohibited. So it wouldn't work. They still be considered employees. And then again, the court discusses the need to protect workers to prevent a race to the bottom, but it is also arguable that they want to bring in more tax revenue to the state, as misclassifying workers means less taxes that employees have to pay to the state. So that's a totally separate webinar. So more points to consider. If going through the text, there are 2 places, and what I can do if you're interested, I can send you the actual text with my notes on it. So you can see where my thought process lies. But in the text, there are 2 points, 2 subdivisions. Subdivision E deals with bona fide business-to-business contracting relationships. What they are saying, they have 12 points. 1, that the business provider is free from the control and direction of the contracting business. So if I work for an agency, a DJ agency, let's say, I'm technically free from the performance of the work. This actually might not be a good example. If I'm coming back to the accountant retail store example, if the accountant is free from the control and direction of the contracting business entity, right? B, the business service provider is providing services directly to the contracting business rather than to the customers of the contracting business. I can go through all the points, but with business to business relationships, the trickiest part is part B, that you're providing services directly to the contracting business rather than to the customers of the contracting business. So if I'm a DJ that works for an agency, I'm not providing services to the agency, I would be providing services to the end client. So technically, I'd still be considered an employee under subdivision E. With subdivision G, it deals with referral agencies and service providers. It's the same set of points. The difference is they have definitions of referral agencies. So if you run a restaurant and you hire out, if you're in a restaurant, you work for a restaurant and you hire out your employees for, you hire out employees for a catering event. For example, there's a wedding and you outsource an agency to bring you servers. This is the kind of clause that this falls under. And again, in this case, who knows if then the restaurant has to consider them employees because the providers are providing work for the end client, right? So this is where it really gets tricky. This is where I'm not a lawyer comes into play. These 2 clauses are the points that I would say get legal advice on, because if these nuances get corrected, then I think we're in the clear as independent contractors. But It runs deep. They also have defined definitions for what is a referral agency. And one of them is event planning. So that might be something to consider, Dwayne, for the restaurant business, or I'm sorry, for bartending. Something to think about. TR Parker, what's good? What's good? You have a question. You raised your hand. Sean asked, will this be actively enforced by the government IRS, or is this more likely only going to be discovered if contractors decide to sue? Great question. My blanket answer is, I don't know. From what I've read, oh, cool, you're here. From what I've read, yes, there's a chance that it can be enforced by the government IRS now that more taxes are involved. Who's to say you won't get flagged if, for example, you turn in your taxes at the end of the year and they're saying, oh, you were working for X company, or oh, you hired these people as independent contractors, they're actually employees now. You're gonna have to pay them. Here's the thing to also be considerate about. People can retroactively sue you. So this is a big thing that I've learned is possible to do, because this is retroactively applied. So if somebody you've been working with as an independent contractor for so long now turns around and says, I'm an employee, it's a really tough predicament. Again, legal help at this point. I hope that answers somewhat of the question, Sean. It's possible. Enforcement, with new law changes, enforcement is like the other thing that is hard to call, right? Especially because this is brand new. All the lawyers that have spoken are like, we don't know what's gonna happen. This just opens up Pandora's box, essentially, of how this will be enforced, who will this be enforced on, and what's gonna happen. If the LLC is based in Wyoming, maybe not, as a suggested Cali thing. But who knows what, check Wyoming's laws just to be sure that they don't follow this ABC test, because there are about 20 states nationally that have already enacted this for independent contractors and employers. I think like Boston is one of them, for sure, for sure. Has this been helpful? Any other questions? Oh, there were other questions. I know, Mickey, you had asked. Again, my blanket statement is, I don't know. And I think, so some of Mickey's questions were, who determines who is the employee of record under this law? The burden of proof falls on the employer, right? So knowing your situation, if the organizer of all these events, of all the rehearsals, is the one responsible for bringing people on and finding gigs, they have the burden of proof to show that everybody who's working for her is an independent contractor, not an employee. So, so that's who's on the hook. Dwayne, I'm gonna get to your question right after this. If a singer or artist works for multiple employers as an independent contractor throughout, what if a singer or artist works for multiple employers as an IC throughout the year? Then it's possible to do, I guess, if the criteria is met. If not, then all the employers have to be held responsible. I'm guessing how they normally would. Because we've done acting work. So even if we go in and do a 5 and under, we're still treated as an employee. They're still taking taxes out of our checks, out of our residual checks. So it's been treated as that regardless, even if we work for a day or even half a day. So I think it's treated the same. They just have to handle it. If it's independent contractors, I think it's business as usual, that we're responsible for taxes and all that kind of stuff. If it's seasonal, that was a thing that was brought up. If, let's say, an accountant is brought on just for tax season, and then on April 16th, they're like, we're good, thank you. Is that employee fired? Are they entitled to unemployment benefits? all these are questions that get thrown up in the air now because of this switch. I don't know what actual enforcement at AB5 looks like outside of like tax stuff, I guess. Oh no, I'm sorry, I do. I don't know, but I had heard that there's tons of repercussions, there's penalties, there's fees, it runs deep. If you're interested, for everybody here that's listening, if you're interested, I can put together where my resources came from. So if you want to look further, the videos, text, whatnot, if you're interested in doing your own research and want to dig in, it's a reference that you can have. Let me know and I'll send it over to you. Dwayne, so if I hire a DJ to do a gig I can't do, technically, I think they're my employee. Technically. But if I'm like, hey, listen, I can't do this, you need to talk with them directly, I'm out of the picture. Maybe that's the way, that I'm just passing along the information as opposed to actively like signing contracts with them and saying, you got to do this and do that. I'm guessing that would be like how my situation may have to work in that context. Any other questions, thoughts? Oh, I think I'm live streaming. Oh, maybe not. Okay, great. I thought I was live streaming on Facebook. I guess I'm not. Cool, short and sweet. This is really about awareness. So you know what I've done also? I've actually called Assemblywoman Lorena Gonzalez's office to talk to people about this. The lady who would be the most informed about this issue has yet to pick up my call. I've emailed her multiple times. So I'm really trying to hear it from the source and get what I can. I've also contacted a lawyer about this, so I'm gonna ask questions. If you have questions, like send them to me and I'll be more than happy to ask, because I want all us to work. I want all of us to be able to continue what we're doing, and because this has the potential to really screw all of us up, and I don't, right. And so I wanna, like, however I can help you, my guy, like I want to. Yes, I can, I'll do that. So we're all in the same boat. And so however we can help each other, you know, I just know that I got your back. Any other questions? Great, thanks, Sean. Thank you, Mickey. For sure. My pleasure. Again, hit me up if you have more thoughts. I love talking about this stuff and trying to figure out solutions, man. It's really important. As I get older, I see how important local politics really can impact our lives moving forward. So this stuff matters, unfortunately, for sure. And if anything else comes up, you know, definitely. Y'all know how to reach me. And if whatever I find, I'll give you the heads up. Cool. Until the next time, talk soon, y'all.